All right, welcome back again, Realty Pros. Today we have one of our attorney friends, Vaughn Royal, with us today. We're going to be talking about probate and estate sales. We want you guys to be well informed about this listing type and what it is that you need to know to be able to provide the best service to your clients. Mr. Royal has been a valued resource to us for many years now, and we wanted you guys to be able to glean from him directly, okay? So Vaughn has some slides that he's going to share with us, a lot of information he's going to give to you guys as well, and you'll be able to ask questions. And as always with our trainings, they are interactive. So mute yourselves to avoid any feedback, but should you have any questions, feel free to unmute, and where appropriate, go ahead and ask. So we'll go ahead and get started. Welcome, Mr. Royal. How are you today?
I'm well, thank you, Jasmine. Let me just mute my phone here so it doesn't start making noises while we're okay. Can you see my title slide? Can everyone see that?
We sure can.
Okay, that's fine. Well, good afternoon, and it's a pleasure to have an opportunity to speak with all of you today. Two of my principal areas of practice are real estate and wills and probate. So this all comes together very well in terms of, I think, what is the things that are important to you as you're dealing with situations in which you discover that there is a death involved with a potential listing, either before you take the listing or perhaps even after you've taken the listing. I'm licensed to practice in DC, Maryland, and Virginia, so there will be things in this presentation that will be specific to each of the three jurisdictions. I don't know how many, I suspect a lot of you are DC and Maryland, but there may be also some Virginia licensed agents in the group as well. So there'll be some information about that.
We are the DMV, DC, Maryland, right, and Virginia.
Second, I'm trying to get, there we go, my slide changed. The way I've organized this is primarily around 6 questions that I think as a potential listing agent you always want to ask. The first question, which we'll talk about, is, and this is fairly obvious, who owns the real estate? Secondly, was the person who died the only owner of the real estate? When did the owner die? And we'll talk about why that's relevant. In what state was the owner living when he or she died? Has an estate been opened in probate court for the person who died? Was the real estate put into a trust by the owner during his or her lifetime? And finally, is someone selling or trying to sell using a power of attorney? And that's perhaps to some extent a trick question, but it does happen, even in situations in which a death has occurred. And we'll talk a bit about that. So the first question to always ask, of course, and you would do this anyway, is who owns the real estate? You always have to do some due diligence, but that's not a substitute in the final analysis for a title search or having title examined. Where do you go for the information? Well, to some extent, it's going to be contained potentially in tax and assessment records, but that's not necessarily the end point of it. For Maryland and Virginia, if you look at tax and assessment records, sometimes it's a pretty good indication of who actually owns the property in a way that's going to be consistent with what will come up on a title search. But when you look, for example, in Maryland at the SDAT database, their database fields only hold so much information. And it's not always helpful when you have multiple owners or trusts or other entities involved, but it's a starting point. In the District of Columbia, the database fields in the tax records, again, you have limits as to the number of characters you can put that they can put in the field. But the records in the District of Columbia sometimes don't show the name and mailing address of the owner, but they may show the name and mailing address for where the tax bills are supposed to go. And that may or may not be the owner of the property. But again, it's a starting point. Sometimes the potential lister of the property has a deed. And the deed may be accurate, but it may be out of date. And there may be a later deed, which is relevant. It may be that the title was in the name of the person who wants to list the property at one point, but then there may be a later deed creating a joint tenancy or tenancy by the entireties or something like that. And that's, of course, why title searches are done, and you don't just rely on tax records. So you always want to know, was the person who died the only owner of the real estate? If so, then you may only have one estate to deal with. But if not, then you need to know what was the relationship between the owners, and are the multiple owners living or deceased? You know about tenants by the entireties. That means it's owned by spouses, and the last surviving spouse becomes the sole owner. You can have multiple owners who are not married, joint tenants with right of survivorship, and again, the last surviving co-tenant or co-owner becomes the sole owner. But you need to know, are there other surviving co-owners? And of course, you can have tenancy in common in all three local jurisdictions. The person who died had a partial interest in the property, a percentage interest typically, and if it doesn't matter whether the other tenants in common are living or not in one sense, because if they are living, the person who died can only sell his or her percentage interest. So if that person had a 33% interest, that's all that they can sell unless there's participation of the other tenants in common in the property. If all of the tenants in common have died, then you may have a further complication, because again, following my example, if the person who died you're dealing with had a 33% interest and you want to sell the other 66%, if the others have died, you're going to have to find out something about the estates of the other tenants in common who are deceased. Have estates been opened for them? Are they willing to participate in a sale? So you may have to do some coordination of interests with tenants in common property to get a sale together. Next question to ask is, when did the owner die? And let me just digress a little bit and tell you that typically for things that we as lawyers do and you as real estate professionals do, you want to look, you're generally dealing with current law. What is the law that is in effect today? But in DC, Maryland, Virginia, and every other state, your legislatures meet every year. In DC, they meet more often than that, and the laws change. So when we are dealing with probate, we are not necessarily dealing with the law that is in effect now. We have to look at the law, what was in effect when the person died. I have on my bookshelves copies of old probate laws for DC, Maryland, and Virginia going back a number of years, because if someone says to me, well, the person died in 1985, well, I have to look up the law that was in effect in 1985. And that also is important to determine when probate is required and when the property's title may pass without probate. And I'm going to break it down a little bit here by state for you, and I don't expect you to, I don't think you need to learn this. You don't need to memorize it, but it's helpful for you, I think, to know why the date of death is important. The first category, well, let me jump to the current law. You all know that if you're dealing with DC or you're dealing with Maryland, there's going to have to be and properties in the title in the name of one person who died. There's going to have to be an estate opened, letters of administration issued, personal representative appointed, and when that person has the authority to sign a listing agreement, sign a contract of sale, sign documents at settlement. That was not always true. In the District of Columbia, for example, if the person died before January 1, 1981, there was no probate required in court, and title to the property would pass to the heirs or the beneficiaries if the person had a will without probate. And what would be done with it would be that the will or a list of heirs would be recorded in the public land records before the real estate could be sold. And you may be thinking, well, why is this even important? This is 2021, this is a long time ago. Well, there is still real estate in the District of Columbia titled in the name of people who died before 1981. The family didn't do anything about it. I did an estate 2 or 3 years ago for someone who died in 1967 in the District of Columbia. And believe me, I had to go back and do some I don't, it wasn't exactly formal continuing legal education, but I had to go back and do some learning before I was able to do what needed to be done for that property to be sold. So the first category is in the district is property before that the person died before 1981. After 1981, probate is required. And that's the situation you're most familiar with. The personal representative has to be appointed and they sign a deed to transfer the property. But there is a special category between 1981 and June 30, 1985. And if the person died within that time frame, a court order approving the sale may be required. And that, of course, may slow things down a little bit in terms of getting to where you want to be in terms of getting property listed and sold. More so now that we're in COVID times and the court is operating very slowly. For deaths after July 1, 1995, normally a court order is not required to sell. So let's move from the district to Maryland. In Maryland, if you're dealing with someone who died before January 1, 1970, like the district, no probate is required and title passed without probate to the heirs or beneficiaries under the will. But again, to basically provide evidence in the land records sufficient to sell the property, either the will or a list of heirs or something like that is going to have to be recorded in the public records before the real estate can be sold. Deaths after January 1, 1970 in Maryland, probate is required. And that's again the most familiar situation to you where the personal representative has to be appointed and signs a deed of settlement. For those of you who practice on the other side of the Potomac, Virginia, Virginia is different about a lot of things, but Virginia still does not generally require probate when title to the property is in the name of a single individual who died. But again, before the property can be sold, either the will or a list of heirs has to be recorded in the public records, just like a deed, and that is sufficient to provide evidence of ownership of the property following death. Exception: probate in Virginia in court may be required if somebody signed a will that said, I want my personal representative to sell the property. And under those circumstances, probate will have to be opened. And so in Virginia, especially if there is a will, it needs to be reviewed to find out if simply recording the will and the list of heirs is sufficient, or if there have to be some court proceedings. That's kind of unusual. Most people don't do it, but it does come up occasionally. Next, always ask is, in what state did the owner live when he or she died? And this, of course, is not necessarily the same place that the real estate is located. You have people who lived in the district or the DMV area, and they've gone to retire in some other part of the country, Carolinas, Florida, what have you. So you need to know, have in your notes, where was the owner living when he or she died? Because if the owner was not living in the state where the real estate is located, it may be necessary to open primary probate in the state where the person was living when he or she died. That's the state of domicile. That's the primary probate. And secondarily, it may be necessary to open foreign probate in the state where the real estate is located. This happens a lot within the district, Maryland and Virginia. I've got 2 or 3 cases going right now where people died living in Maryland, but they owned real estate in the district. We open probate in Maryland, get specially certified copies of the Maryland documents from the court there, file them in the district to open foreign probate. It slows it down, but you need to be aware of it because in the district, for example, if you open foreign probate, you shouldn't be selling real estate until 6 months after the foreign probate is opened. Next thing to ask, has an estate already been opened in the probate court for the person who died? And if so, put it in your notes, ask for the information. What court? Is there a case number, contact information for the personal representative, or contact information for the attorney for the estate? This will be invaluable going forward. Trusts. Some of you may have living trusts for your own real estate, or you may have encountered them. But living trusts make it possible to keep assets, including real estate, out of the probate process. If the property is in a living trust and was put there before the person died, you should be asking, who's the trustee? Who's the successor trustee? Because those are the individuals who have the legal authority to list the property, sign a contract, and perform its settlement. Trusts are complicated legal documents. They can run 50 to 100 pages sometimes. And someone needs to review the trust carefully. There may be restrictions or conditions on the sale of the real estate that were imposed by the creator of the trust. The trust might say, for example, this might be a trust by a parent, and the parent may say, well, after I die, I want my son to be able to live in the property for 6 months to a year before it's sold. Well, you need to know that, because if you don't read it, or if someone doesn't read it and inform you of that, the title company's going to read it when it gets to settlement, and then you've got a problem. They're going to say, sorry, this property cannot be sold at this time. So conditions that relate to the sale of the real estate may be in the trust, and so that's why the trust needs to be reviewed. The next always ask, and as I said, this is a bit of a trick question because some of you may already know the answer to this, is someone selling or trying to sell using a power of attorney? Well, a power of attorney becomes null and void the moment that the person who signed it died, period. So if someone, under any circumstances, says to you, well, I'm selling this property and I have a power of attorney, the first question should be, is the person who signed it living? If the answer is no, the power of attorney cannot be used. And a power of attorney is not a substitute for the probate process. Okay, those are the 6 questions, but there are a few other points I'd like to make to you, the things you may encounter or will encounter. Heir property, multi-generational situations. This is the kind of situation where someone, such as a grandparent or great-grandparent, died without a will, and the property may be passing or have passed through multiple generations, which are going to require opening separate estates for people who've never had estates opened for them. It's going to have to be done before clear title can be passed to the property through a sale of property. It can be a lot of work. It can require sometimes hiring a genealogist to come up with vital records, death certificates, marriage certificates, birth certificates, and all that. And it can take months or years because you may have to see multiple estates opened, and they may be in different states. Okay, here's one of my pet situations that I used to run into occasionally. I did settlements for 15 years or so. And the question that sometimes comes up, and this can come up not only when the person who's selling the property is alive, but also when heirs or beneficiaries are inheriting and the property is being sold, they want to know, when am I going to get my money? We know that a lot of settlement agents disperse at the table, and I would strongly recommend to you that if an heir or a beneficiary asks you, when do I get the money after settlement, do not answer the question. Refer them to the personal representative, the estate attorney, or someone who is connected with the estate of the trust that's doing the sale. In DC and Maryland, it's convenient and it's good that real estate can immediately be sold after the estate is open. That means that once the estate is opened and the personal representative has letters of administration, they have the legal authority to sign a listing agreement, contract of sale, performance settlement, and all that. But that doesn't mean that if the sale takes place, say 2 months after the estate is opened, that the net proceeds can or should be immediately dispersed to family, heirs, and beneficiaries after the settlement is concluded. In the District of Columbia, and Maryland for that matter, creditors have 6 months periods to come forward with claims against the estate. So for example, let's assume that the property is listed and sold within 2 or 3 months after the estate is opened. There is still time, for example, for a credit card company to come forward with a claim saying that the credit card wasn't paid. There's time for doctors and hospitals to come forward with claims saying, well, the person was ill and medical services were rendered and they weren't paid for, and on and on. And if the personal representative allows distribution of money immediately after the sale, and the time for creditors to file claims has not elapsed, and the money is all gone, guess who is going to be responsible for paying off those claims out of his or her own pocket? That's the personal representative. And that's one reason personal representatives generally do not distribute money until the time for filing claims has expired. Plus, of course, taxes need to be paid for the decedent. Sometimes the estate may have to pay taxes if the property is sold for more than the date of death value of the property. Court costs, legal fees, all that need to be paid. And then final distribution can be made. In Virginia, it's a little bit different because creditors have 1 year after the date of death to come forward and make claims against the estate. So for that reason, if property is being sold, and yes, you can sell in Virginia within that 1 year, title companies are going to either hold all the proceeds until the year has expired, or they're going to require the personal representative to purchase a bond to protect creditors in the event that proceeds are distributed and creditors come forward with claims. So again, don't let people think that just because money's being dispersed at the table, it's going to be distributed from the estate to the heirs or beneficiaries immediately. It may not be the case. We say a couple of words about transfer on death deeds. These are relatively new. They're recognized in DC, Maryland, and Virginia. They can be used to avoid or try to avoid probate. Transfer on death deed is a relatively simple document. You can pick up the forms online, actually, from the DC Recorder of Deeds website. Or if you happen to go down to the office, it's just a 1 or 2 page form. And the transfer on death deed, it's kind of like a pay on death bank account, if you're familiar with those. A pay on death bank account says that it's my account, but upon my death and proof of my death be provided to the bank is to pay the money in the account to a person I've named. And it's the same basic sort of thing for real estate. During the lifetime of the owner can sign the transfer on death deed saying that upon my death, I want this property to belong to so-and-so, family, friend, what have you. It can be changed or modified or revoked as long as the owner of the property is alive. And if they record it in land records, recorder of deeds or circuit court or what have you, upon proof of the death, the named beneficiary becomes the new owner automatically. It is normally required to file something in land records establishing the death. And if they do it properly, then the real estate is not part of the probate estate of the person who died. Now, these are relatively new, and title companies are not fully comfortable with them. And every time I've seen, excuse me, I've seen one used, title and properties being sold following the death of the owner, the title company has said, well, we want the heirs and beneficiaries of the will to sign waivers indicating that they're fine with this and they're not going to contest it. So it's available, it's out there, but just be aware of the fact that these have only been around for maybe 10, 15 years, and title companies are being very naturally conservative. They don't want to get stuck with a situation in which someone contests the transfer on death deed, and so they're going to likely want the heirs or the beneficiaries of the will to sign waivers. Okay, this comes up occasionally, and some of you may have seen this. What if a listing agreement or contract is signed by someone who didn't have legal authority to sign it? Someone, for example, knows that there's been a death of the owner of the property, and the person says to you, well, I'm going to be the personal representative. Well, they may not be at the time they sign the listing agreement, or they might not be when they sign the contract. And if they're not, then they don't have the legal authority to sign at that moment. But if they later become the personal representative, and they get proper appointment and their letters of administration from the court, then that listing agreement or contract probably is going to be binding, and you can go forward with that. But if that person who said to you, I'm going to become the personal representative, does not become the personal representative in fact, or there are actually multiple co-personal representatives who are not on board with the listing or the contract, then what the person did without proper legal authority may not be binding on the estate. Last point, slightly off point, but I mean, it's something just to think about. As agents, you, and dealing with the estates of people who died, you're undoubtedly from time to time going to have death certificates come into your possession. Because title companies, when, for example, when the owner has died, or where there are multiple owners, whether it's tenancy by the entireties or joint tenants with the right of survivorship, they're going to want proof that the co-owners are actually deceased. And I just encourage you to handle death certificates with special care, especially when you're sending them around with unencrypted email, because they contain information that is wonderful for identity theft, such as social security number of people who died, their dates of birth, place of birth, parents' names, mother's maiden name. It is a treasure trove of information for someone who wants to engage in identity theft. So be very careful. If the title company you're dealing with has asked for it and they have a secure portal, use it. If you have the ability to encrypt the document, that's fine too, but just be very careful so that you don't accidentally become part and parcel of something that is going to be a problem for an estate or for a problem for another individual. And those are basically my points. I did not hear any interruptions for questions, but I am happy to take them. I certainly have not covered everything, and if some of you have questions or experiences you'd like to share, please go right ahead. Could not have handled everything that thoroughly.
I have a question. This is Kermon McPayton. So does it make it easier or more difficult when a person has a trust to do the real estate transaction, or is it easier when they just have a will? Because I was under the impression that one of the benefits of having a trust is that it's a smoother transition and it's a lot easier instead of having to go through the probate process.
It is, that is correct. The trust avoids probate, saves probate fees, because probate fees in court are based on the size of the estate. And if you can keep, $500,000 worth of assets, real estate assets out, then the probate fees are going to be lower. It's going to be quicker. You still have to be careful about, I say you, I mean the trustee still has to be careful about creditors, because just because the property is put in trust doesn't mean that it's not liable to be used to pay creditors if there are unpaid debts or taxes. So still, but nonetheless, I mean, you can get it to market, should be able to get it to market quickly as long as there are no conditions in the trust. For example, the one that I mentioned was that the trust says that so-and-so has the right to live in the property for 6 months or a year after death. So, but barring that kind of condition, if it's a kind of trust where it's anticipated that the assets are going to be liquidated quickly, sure, it's a good thing.
So this is Dee, and on following what Kermon just said, he's talking about trust, and you mentioned creditors. So what happens if the creditors outweigh what the estate is worth, and how do you prioritize once you get through, IRS and what do you call taxes, property taxes and those things? How do you prioritize after that?
Every state, DC, Maryland, and Virginia,
They're all different.
has a set of priorities dealing with who gets paid in what order if there is not enough to cover everything. Not surprisingly, things like court costs are going to be at the top of the list. Governmental things that are owed to governments, like taxes, are going to be very high on the list also. Lower on the list, well, of course, if it's real estate and if there's a mortgage on it, they're going to get paid first anyway because they've got a secured lien. But leaving that aside for the moment, I mean, things like credit cards, doctors, ordinary unsecured creditors are going to be toward the bottom. And then, of course, whatever is left, if anything, will go to the heirs or beneficiaries.
So what happens when you cannot pay the creditors who are at the bottom of the list?
Well, it goes as far as the money goes as far as it can go. If the money only goes to cover the first 2 or 3 categories, that's as far as it goes. The lower categories will not be paid, and there will not be anything for inheritance.
So as the realtor, all you can do is make sure the property is sold. But then after that, you don't have anything to do with any of the rest of that. And you should have your client refer back to the probate attorney.
Absolutely.
Okay.
And this will come up with short sales from time to time also, especially if the real estate is the only principal asset in the estate. But I mean, it's as the real estate agent, as a settlement agent, it's not your responsibility. It is the responsibility of the personal representative to receive the money following the sale of the property and pay it in the proper order, proper priorities to those who are entitled to it.
This is Kermon McPayton again, Attorney Royal. One of the, I think maybe it's a misconception, but something that I've heard all the time was that with a trust, everything is private. So the creditors, so nothing is listed. Let's say, for example, within probate, it's listed in the newspaper and it's public and all of that, so everybody knows. But the understanding used to be, or was, that trusts are private, so that nobody would know, and so nobody would have access to the fact that the person's died, where they could start making claims even legitimately or fraudulently and say, hey, this person owed me money or what have you. So are you saying that's not the case, and that they still have the creditors and stuff still have access to it, or what? Well,
I'm going to give you a mixed answer to your question. You're correct that one of the reasons people create trusts is for privacy, because the trusts are normal. A will is going to be recorded in land records, not land records, in court records after the person dies. And that's public record for anyone to see. And in addition to a will, in many instances, an inventory is going to have to be made about part of the court record, itemizing and valuing everything the person owned at the time of death, including real estate, furniture, motor vehicles,
right,
bank accounts,
exactly.
what have you.
Okay.
That is not done with a trust. But in order to get protection from creditors, what should be done in the case of a trust is publish a notice in a newspaper that the person has died. There is a trust, and that if anybody has a claim against the trust, they should make it within 6 months in the case of DC and Maryland. So, but that does not require publishing information as to the value of the assets in the trust. That is simply a notice to creditors to come forward and speak up. Otherwise, they may lose their ability to do so. We do something similar for normal probate estates, but it can also be done for a trust.
Okay, and does that supersede whatever the person who created the trust wanted? For example, if they wanted their money to be dispersed in a certain manner, but there are, let's say, like you said, they're creditors, so the creditors still have, they have first position, or they still have they can still be paid first before the trust is executed the way that the person who created it wanted it to be. So if they wanted it to go, everything to go to their children, their grandchildren, the creditors can still step in ahead of that and get whatever's owed to them, and then the children and grandchildren get either what's left, if anything?
That's absolutely correct. I mean, the distribution under the trust is what is left after taking care of administrative expenses, taxes, and debts. Those all, those, assuming the debts are legitimate, those all have to be paid first.
Okay, got it.
You can't avoid your creditors by putting stuff in trust and saying, I don't want my debts paid. Be nice, but it doesn't work. Now, there may be some other things you can do with different kinds of trusts, irrevocable trusts, as opposed to the kinds of revocable trusts that are most commonly used, which may have some benefit there, but not your normal revocable living trust.
Okay. All right, great. Thank you.
Certainly.
Yvonne, I have a quick question. This is Curtis. I want to thank you for your time. All the information that you've been presenting has been very, very useful. And I guess because we're all talking about trust, I had a question in regards to a investor looking to get into, real estate investing, various, purchasing various properties to rent, what have you. Should they actually form, if they wanted to have a trust set in place, would it benefit them to form the trust before they start to actually acquire various rental properties, assets, real estate assets? Or can they form the trust after they have, say, 3 properties or a certain amount of properties, and now they want to do the trust? Does it benefit them at all to do it, kind of out the gate before they really start to acquire properties? Or does it really not matter where they can, down the road, form a trust and then put the properties in the trust?
Well, there are several considerations here. One is that every time you transfer property, as you well know, you may be dealing with recordation and transfer taxes. And that is also true with respect to some trusts, not all trusts. Revocable living trusts, where the person who creates it is the only beneficiary, are not going to trigger recordation and transfer taxes. But there's still going to be some transactional fees to a title company or attorney to do a deed. If you are talking about the District of Columbia, here's something you may want to write down if you're not aware of it. The rent control small estate exemption, in other words, 4 or fewer units being exempt from rent control, does not apply in the District of Columbia to property that is owned by a revocable trust. And their bills have been put before the City Council on several occasions that they've not passed to change it because it doesn't make a whole lot of sense. But that is the law, and that's something that an investor, especially for the District of Columbia, needs to be aware of. It's no different than putting the property in an LLC or a corporation. Again, no rent control exemption, because in the District of Columbia, to get the small landlords 4 or fewer units rent control exemption, it must be owned by a quote unquote natural person. And the law at the present time is that LLCs, corporations, and revocable living trusts are not natural persons. But the other thing I would just say is that, if in terms of reducing transactional costs, if you're buying real estate and the lender will allow you to purchase it in the name of the trust, why not? It saves a later transfer. Some lenders say yes, some lenders will say no.
Okay, thank you.
Some lenders make you take property out of trust for refinancing and put it back in afterward.
Okay. Excellent. Thank you.
Certainly.
Okay, I'm sorry, this is Kermon again. Just to follow up on Kirsten's question. So what would be the benefit to, especially in DC, to be doing investment properties in an LLC? Is there any benefit to that? Because we've had, I've had people who were trying to do things even just to refinance, and they said they had to take it out of the trust to refinance it and put it back in. So is there first of all, is there any benefit to having an LLC and putting it in the LLC or the or corporation or whatever, Is there a benefit to doing it that way, or would it behoove you just to put it in a trust? Would that be the better way to do it, or what?
You know, LLCs and corporations, one of the reasons people create them is to limit liability in the event that, you know, if it's investment property, in the event that a tenant ever sues, to try and protect the assets of the owner. But, sorry, I just lost my train of thought for a second. The LLC is not necessarily, in most cases, going to be helpful as an estate planning tool. It's not going to entitle you to a rent control exemption if that's important to you. And, you know, it also may put you in a different category for lender underwriting. They may have different underwriting standards for lending to a corporation or an LLC as opposed to an individual. So, you know, those are things to think about. And of course, there are transactional costs in taking it out and putting it back in. Oh, also, you mentioned LLC. When you put property, you can put property in the District of Maryland into an irrevocable living trust without recordation transfer taxes. That is not true. And you can also take it out without recordation transfer taxes if you have to do it to refinance. But that is not true in LLC. And if you transfer property from an individual to an LLC, they will impose recordation and transfer taxes on it at the standard rates. However, speaking of the district in particular, if you want to reduce the recordation and transfer taxes, they will allow you to state the consideration at a figure no less than 35% of the tax assessed value. That will lower the recordation transfer taxes, obviously, because it's going to be, the percentages will be levied on the stated consideration. But this could be a problem for some people. You may be creating a low tax basis for the property in the LLC. So if the property, just to give really simple numbers here, the property is worth $100,000, and to reduce the recordation and transfer taxes as much as possible, putting the property in an LLC, you say, well, I'll value it at 35% of that at $35,000. That becomes the tax basis of the property in the hands of the LLC. And if the LLC later sells it, the gain is going to be measured, basically the sale price minus that $35,000, not the sale price minus $100,000 it was actually worth. So sorry for the long answer.
No, I thank you. That makes a lot of sense. That clears up a lot of things. Thank you so much.
Mm-hmm.
You guys are doing a phenomenal job, Vaughn. That was very insightful information. Thank you for your thoughtfulness. And you guys are asking some excellent questions. Does anybody else have any other questions they'd like to ask?
This is Dee again, Attorney Royal. Would you like to cite one of your interesting cases where there were, heirs? Okay, so there's no will. You have heirs that died earlier, like in the 80s, let's say in the 80s, and that there are several owners that are in the property, and then those owners died at different times, and the estate is then split amongst several families. You were talking about how that happens, but can you cite a specific case so that we could hear how that actually works?
Well, I have one that I'm just getting in the early stages of now, where there was a husband and wife who owned a house in the district as tenants by the entireties. And I think the wife died first, the husband died second. And of course, the husband, being the second to die, became the sole owner of the property. And they had, I believe, 5 children, a couple of whom died before the parents. One died after the parents, and 2 are living. And so the latest count is that I'm going to have to open at least 3 estates, and there may be proceeds that are going to be going not only to the living children, but also to the children of the child who predeceased the parents. These are reasons sometimes why it's really important to have a will, because you can have unintended results and people you don't even know winding up with value or proceeds from the sale of your real estate. But I mean, I've had cases where I've had to open 3 estates to clear title so that a property could be sold. It's not unusual. And, you know, I've referred a matter now to another attorney in South Carolina that may involve, it's 3 or 4 generations, and I don't know how many estates are going to have to open. It's like 100 acres of farmland and forest land down there that people have just died without wills, and it's just been passing. You know, people have lived on it and worked it and sold the trees and forests on it, but now some of the younger people in the family are saying, look, we're not getting any benefit from this, and we'd like to get the benefit from what our grandparents and great grandparents, the labors that they put into this. So it is not unusual. Also, you can run into, this is slightly off topic, but with this air property situation, especially in the district, it's not unusual to see a situation where somebody died 10 or 20 years ago and the property still has senior citizen tax benefits and homestead on it. And you know what what's going to happen there when when the word gets to the tax office.
Oh, yeah. Okay, thank you. Because I've seen at least one example where, you know, 3 sisters own the property together, and the 3 sisters all died at different times. And so, and 2 of the 3 sisters had no children. So all of their heirs are all nieces and nephews, and all of that needs to be gone through. And that's a bunch of, you know, it takes, like you say, sometimes it can take years. It's
It
just,
can. It can take
especially
years.
if
I'm sorry, go ahead.
somebody moves away, that makes it really difficult.
You know, yeah, I mean, I've worked on tracking people, family members who have not been seen in 10 and 20 years because they're needed to clear title on property.
Attorney Vaughn, and I don't want to belabor the point, but and this is Dee's fault because she made me think about something that's really getting ready to happen. As a matter of fact, it's a situation with my family. So I'm going to give you a scenario and you just kind of tell me what you think very quickly. So had a person own a property in DC. The husband died, the wife still lived there, she owned the property. But she had a reverse mortgage on the property, and she had also had gotten a grant from DC government to fix up the property, but she still had a reverse mortgage on the property. Now, when she dies, she has no will. We're trying to get her to do a will, but she has no will, and she has 2 children, 2 heirs. So if she dies without that will, with that property, and it goes to probate, would it automatically go to those children, or can the grandchildren also make claim to that that property? And how would that affect as far as her having the reverse mortgage?
If she dies unmarried, survived by 2 children, and she does not have any other children who died before her.
She does.
Well, if let's say she had a 3rd child, and the 3rd child died before her, and that 3rd child had children. So if she dies without a will, given your example, if there are 2 living children and grandchildren of a 3rd child who predeceased, it would be one third to each of the living children and 1/3 to be divided among the grandchildren.
Okay. And what about the reverse mortgage?
Has to be paid within typically 6 months of death, or whenever the homeowner moves out permanently.
Okay.
I mean, you that's pretty standard, the 6 months. I mean, some reverse mortgage companies will give some flexibility, and they'll give, if you give them a good reason and you make a written request, they'll give additional time.
Mm-hmm.
But normally it's 6 months.
Okay.
And the DC, you said she got money from DC?
Yeah, she got like a grant or something, when they were giving for people to be able to fix their homes up to make them, have
Mhm.
things that was necessary to do. And she was under, as a senior citizen, she was under the income, level and all of that. So they gave her, from my understanding, it was a grant. So it wasn't something they said they had to be paid back, but it was still a grant. But I think one of the stipulations was that she had to live there for a certain period of time, couldn't sell the house, which I think that time period is up. But yeah, it was a grant.
Well, I mean, without seeing the paperwork, I couldn't really comment on that. But I mean, if the district put a deed of trust on the house, too, it probably contains a due on sale clause or due on transfer clause. You have to be sensitive to.
Gotcha. All right. Thank you.
All right, Kerman.
I'm done. Thank you. I'm done.
He had good questions.
These are great questions. You guys are wonderful. And again, Vaughn, this has been very insightful information. We're going to begin to wrap it up for today. We have 3 minutes before the end of our training. So if anybody has any last minute thoughts or questions, you have about 2.5 minutes or so. Or Vaughn, if you'd like to leave us with any kind of lasting, statements, you have a couple minutes there. I'm going to go ahead and turn it back over to you.
Well, I don't really have anything at prepared conclusion other than to just say that, I mean, I've seen so many situations. I used to do settlements. I don't do them anymore, but I mean, so many settlements are situations in which agents who perhaps did not ask the right questions get surprised further down the road when they're preparing to list a property, when they discover that there are additional ownership interests or someone has died. So I think it's important to do the best that you can for your client, to ask those 6 questions and any others that may come to your mind, so that you can provide a good service to your client and avoid surprises to yourself and to anyone else involved in the transaction.
Awesome. Thank you so much. Anybody else? Well, Vaughn, you have been wonderful today. Would you be willing to send us a copy of your slides? That was very pertinent information, and I want to make sure that they can go ahead and digest those 6 questions. Our trainings are recorded, however, so they can go back and watch the video at any time, but I want to make sure that we digest that because it was very rich. Thank you again for joining us today.
Well, you're very welcome. I'll email you the PowerPoint slides as a PDF. Which you can
Perfect.
share.
Thank you so much, because we definitely want to be able to share those 6 questions so that we are prepared to give our clients the best service possible. And we don't want to be surprised down the road anticipating settlement and come up with some type of issue like this, guys. So let's jump on it in advance, ask those pertinent questions, and have a plan for success. Thank you guys so much. We're going to go ahead and begin to close out for today. If you guys need anything, let us know, but I will go ahead and stop the recording now.